Welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I'm going to be your employment lawyer for the next 30 minutes or so, answering all your questions about all things employment law. As you can see on the screen, I'm an employment lawyer at Samfiru, Tumarkin, LLP, which, as always, is Canada's leading employee side employment law firm. A couple housekeeping notes before we get started. If you want to get a hold of us, you can do so during the broadcast or outside of the broadcast. At employmentlawyer.ca, help at employmentlawyer.ca, and 1-855-821-5900. Okay, we're waiting for the questions to come up, unless I don't have them. Nope. I think I'm still waiting for the questions to come up. Sorry about that. Still waiting for the questions, but I understand that there are questions. Here we are. Here they are. They're getting displayed now. Okay. So, thanks for your patience, everybody. Okay, so there's a specific employer that there are questions about. I'm not going to give the employer's name. Just say that this particular employer in BC does not grant employees BC sick days and does not pay them. What can employees do? They've reported this to HR, to Human Resources, and she says nothing. Well, let me tackle that second one first. Human Resources isn't there for your benefit. It's there for generally speaking, it's there for the company's benefit. It's there for the employer to make sure that it's limiting its liability and that it's complying with the law to the extent it's required to, at least as far as legal requirements and business meet, because legal requirements often for businesses are just a cost of doing business. And so, but it's Human Resources is not there for you. It's not there for your protection. It's there for the company's protection, just generally speaking. So that's number one. Number two, you have, under the Employment Standards Act, and this particular employer who is regulated by the Employment Standards Act, you have ground floor rights that can't be abridged, including the right to sick days, certain amount of sick days, and if I don't even understand what this means by not granting sick days. I believe the legislation talks about unpaid sick days. It's been a while since I've checked on the new changes, but if the employer is violating your entitlements, you can make a claim before the Employment Standards Branch. And the claim could be, this particular employer is quite large, not only for remedy for whatever the breach is, but also for administrative penalties against the employer if they are in fact violating the sick day granting, as you say. I'm not sure that they are. I'd have to look up the exact wording of what it is you're entitled to under the Act. I think it's 5 unpaid sick days or something like that. But if it's being violated, you can make that complaint. Now, the downside of doing that through the Employment Standards Branch is, you might sour your relationship with the employer, and you might not work there that long. But on the other hand, this isn't necessarily the greatest employer to work for, and it might result in actually outsized financial penalties to your benefit because of the administrative penalties. So there are things you can do, but you may want to talk to an employment lawyer. But this is probably something, given what's being violated here, that you're going to want to run on your own through the Employment Standards Branch. I don't think it makes cost sense to get a lawyer to help you. Okay, next question. What if an employee informs employer of accommodation needed and nothing is initiated on time, and his condition gets worse because of working without accommodation to the point of having to stop working? That's a really interesting question. So a failure to accommodate to the point of undue hardship triggers human rights penalties, human rights damages. But in British Columbia, for example, and I don't know where you are, but in British Columbia, the exclusive human rights jurisdiction is granted to the Human Rights Tribunal, which we'll just say it due to resource constraints, it's backlogged by 5 years. It takes 5 years, according to them. I suspect it's longer to get a resolution from filing a complaint through the adjudication process. So it doesn't leave you much of a. I mean, if something takes 5 years to get a resolution on, it's not really an actual remedy that you can avail yourself of. Now, you also, if you're terminated, and they haven't provided you these accommodations, there might be a battle over whether or not your employment was frustrated by your injuries and the accommodation requirement, but that's not what's happening here. What is happening is they're not providing you with these accommodations, and because this is a really hard, so you have to be able to medically prove that the lack of accommodations caused your condition to get worse. And I think medically that's going to be really challenging. I'm not sure how many doctors would agree with that, and be able to attach their opinion to that on causation. But the problem is for you now, you can't work, right? And so if you can't work, no amount of accommodation is going to get you back in the job. And if this inability to work is on a permanent basis, or you can't do core components of your job on a permanent basis, your employment is going to be what's called frustrated. Now, frustration of contract or medical frustration is where, through no fault of the employee or the employer, through an outside third-party reason, in this case, a medical issue, you're unable to perform the core functions of your job. The obligations of employee and employer under the employment contract are extinguished. It's a fancy way of saying effectively you lose your job and your right to severance. Okay, it's brutal. It's a brutal situation for employees when it happens. It's especially because they're already dealing with serious health issues, and then they lose all of their rights as well under the contract of the employment. So, or the contract of employment. So you're sort of moving into that realm if this is on a permanent basis. If this is just a minor, I'm hoping for you had a setback because you didn't get the accommodations, and that caused you, through lack of accommodations, caused your health to get worse. You can get a doctor to say that you have to take some time off work, you get better, be able to go back to work with accommodations. That's what I'm hoping for you. Okay. And then if they don't give you those accommodations, then I would talk to a lawyer, and an employment lawyer, and the moderator will put our contact information on the screen. But I would talk to an employment lawyer, because at that point you may have recourse in terms of either through the lawyer pushing for those accommodations, or claiming that your employment has been constructively dismissed because the accommodations haven't been provided. It's really what you're trying to do, at least in British Columbia, is avoid having your only recourse be the human rights regime, because it will take a very long time to get that resolved. But I would, first things first, you want to get back to the point where you can get back to work, and then I think you if they continue to not provide you with accommodations at that point, you need to talk to an employment lawyer. Question from Lynn. What about if an employer is expecting to respond to texts and calls when you're not on the clock, or make you check cameras while you're not on the clock? Well, how much time is this eating up for you, right? Like, is this 40% additional unpaid work that's happening, or is this 3 minutes, or is it 3 minutes, but it might be in the middle of the night, it's an interesting question. So what you're asking for is, should you be paid for this? Yeah, probably. Unless you're in management, you should probably be paid for this. If you push for that, or you try to push for a remedy through, the employment standards regime, you're going to sour your employment relationship with your employer. And generally speaking, the way employers look at it is the reward for more work is more work, and if you show that you're taking on additional work and working hard for the company, you'll be in a more favorable position for enhanced responsibility, promotions, etc. So you've got to make I think a really a business evaluation here on what it is you want. If you're at a point where, because it really looks like you're at an inflection point, you can do the extra work and be a company person, and maybe your stock rises, and eventually that leads to good things for you potentially, or you can push back and demand that you're paid for every cent of extra time, and you're going to sour the relationship. So but yes, they should be paying you, and you do have legal remedies for that. But do you want to do that? Depends how serious, how much extra time you're not getting paid for. Like I said, if it's 5 minutes, it's a different evaluation than 20 extra hours a week. Question from Alexia. What does it mean if an employer ignores all your emails while you're on medical leave? I don't. Do you have more context? You're on medical leave. You're on medical leave. You're properly on medical leave. If you say you want to come back from your medical leave and you provide a doctor's note saying you're medically cleared to come back from medical leave, and then they ignore you, it's a termination of your employment. At that point, you have potential severance remedies, and you should talk to an employment lawyer right away, because they can be quite lucrative. They can be, depending upon your age, length of service, position, and the contract that you may have signed. It could be as much as 24 months of pay. But if you're just asking routine questions and they're ignoring you, I mean, your remedy is really nothing at that point. So, but on a larger scale, if you're on a medical leave and they're ignoring you, what does that say about the employment relationship? Is that a place you really want to work for when you get back? So, things to think about. No name on this one. Me and my coworker don't get along, and I'm supposed to work closely with him on an upcoming project. What do I do? He's so annoying, and we don't see eye to eye on things. Yeah, the law isn't going to commercially criminalize, for lack of a better term, employees and employers not getting along with each other. I mean, I don't know if this is your boss or not, but humans get in conflicts with other humans. Humans don't like other humans sometimes. There's no legal remedy for that. I do make the best of it, I guess. You could try to get, listen, this isn't an employment law question, but if you go to the employer, before I was a lawyer, I used to run call centers for major technology corporations. I grew up inside of corporate boardroom, so to speak. I've seen all these things happen hundreds of times. And if you go to your employer and say, I don't get along with this other guy because he's terrible, assign me to something else, you're going to look bad. The other guy's going to look bad. Nobody's going to be happy with you. Usually in this situation, the best resolution is for you guys to figure it out. Usually. Do good work, figure it out. If it's not possible, the worst thing that can happen is you guys get into a conflict and it spills out into where management has to adjudicate it. That's the worst thing, right? So, asking to be reassigned ahead of time is probably better than that, but neither is ideal. The real resolution you probably want here is to figure it out with this guy. But these are all questions that they're personal questions that you have to figure out. From a legal remedy perspective, do you have any? No, none. So I wish you success with that. Okay, this is just spam. Question from Mel. I'm a salaried employee, but routinely work 55 to 60 hours a week. My employer says I'm exempt from overtime because of my job title, coordinator. No, that's not correct. If you're provincially regulated, you absolutely are not exempt. But I don't manage anyone. How can I tell if I'm actually entitled to overtime under BC's Employment Standards Act? It's under the guidelines if you go through the employment standards guidelines, but um, yeah, I mean, you're just because you're a salaried employee doesn't mean you're. I believe you're entitled to. It's been a long time since I've looked at it, but my recollection is yes, you are entitled to overtime that you have been working. And the only exemptions that would apply would be if you were a manager, but manager is narrowly defined and construed under the Employment Standards Act. You have to actually have management function. And even then, there's, it's not it's favorable to the employee. I'll put it that way. So if you don't have any leadership or any direct reports to you and you're a coordinator, absolutely you may have a substantial overtime claim. So the question for you is, how long has this been going on for and how much do they owe you? If it's a lot of money, you may want to talk to a lawyer on this one. If it's like 40 grand, you $40,000, you probably want to talk to an employer to get some assistance, a lawyer to get some assistance on that one. You can see our information on the screen. But you can bring it yourself to the Employment Standards Branch, but you may want some legal assistance. Now, I will say this: if you go the legal route, your relationship with the employer is going to be pretty torched, and I would imagine that they can't get rid of you right away. But do I think you're going to be working there within 2 years? Probably not. Some sort of accommodation where the employer pays you something, but not 100 cents on the dollar, where you're just negotiating with them, maybe a better route. But it all depends on how much they owe you. If they owe you $5,000, I'd figure out a way for them to try to pay you going forward. If they owe you $40,000, that's a different question. So, and also take into account in terms of what you want to do, it's not just legal strategy. It's also legal entitlement, legal strategy. It's also how old are you? What are your job prospects? If you're 62 and there's no chance of you getting a job somewhere else, maybe you just take this one. You just deal with it. But if you're 32 and lots of job prospects, then it's a different story. So you gotta put all those things together and then figure out what the right decision is for you. Hence why you may want to get legal advice after you do the math. Like I said, if it's a few $1,000s, you don't want to get legal advice. Most likely, if it's 40, you may. And given that you're working an extra 15 to 20 hours a week, it may be a lot of money we're talking about here. Okay, we're almost out of questions. Hopefully we have some more. I'll see if I can get some more. Oh, there's some more. My project is delayed, although I was told that I would be transferred to another role or project. My executive director told me to look for a job and voluntarily quit after 2 years of employment. Okay, so if your boss told you should quit, I think you can argue that's a termination. But if you wait too long, it'd be hard to make that. Like, you can argue it's a constructive termination, I think, because they don't want to be your employer anymore. It's iffy though, because you have to win on the evidence, right? So if you're not believed in a testimonial situation that's what was said, or the other side said that you misheard it, or whatever, better if you have it in writing. If you have it in writing, that's perfect. But you may wish to choose it to take it as a termination if you, depending on your contractual situation and what amount of severance you potentially have coming to you. It's not going to be a lot. You've only been there for 2 years, but it is an option. You may want to talk to a lawyer about it. Now, if you're making $48,000 a year, maybe not. But if you're making $300,000 a year, then maybe. So those are things to think about. But you may wish to talk to a lawyer to assess your contractual situation to determine if it's worth it for you to treat this immediately as a constructive termination, because there might be a good potential amount of severance available to you. But you have to do it quickly. If you wait 2 months, it's done. You got to do it right now. But don't do it on your own. Talk to a lawyer first. When I say do it, I mean, do you want to talk to a lawyer now and ask them? this kind of thing, or any constructive dismissal, and just to back up here a second, constructive dismissal is where the actions of the employer effectively terminate your employment, either through breaching of a fundamental term of your employment, or indicating or repudiating your employment contract through its actions, we'll say, which would be this one. Constructive dismissals are hard. You have to get a court to agree that the actions of the employer were tantamount to a termination. If you are wrong about that, you quit and you get zero. Okay, so it's a very big deal. Never do them without a lawyer. Always get the benefit of legal advice when you're talking about constructive dismissal. But for you, and I don't know your name, if you're going to do anything, talk to a lawyer right away, because speed matters for you. Okay. My employer, I think this is Shannon, my employer cut off my extended health benefits while I'm on long-term disability. Can they do that? I believe so. I mean, take a look at your contract. Your employment contract. I don't know. I don't think there's anything that protects you under the Employment Standards Act in that regard. Unfortunately, I don't know the answer to this question, but I believe it's yes. They can in fact do that, and because you're not working, most don't though. Yeah, almost none do. Have you talked to the employer about that? Was it deliberate or was it an error? And just ask them for the rationale behind it, and ask them to provide them the section of the Employment Standards Act that permits them to do that. See what they say. My recollection is that they can, though. So it's just you almost never see it. Jason asks, my employer has asked me to switch locations. Now I'll be having to drive an extra hour each way. This is super inconvenient for me, and I don't want to switch locations. What should I do? This is a very interesting question, Jason. So I think it depends on how long your commute is total, right? You say an extra hour each way. Is that in addition to what it was before? So driving an hour, I think, is probably a reasonable limit. But if you were driving half an hour before and now you have to drive an hour and a half each way, I think that's unreasonable. Now, the question for you is, if you say no, what happens? Okay. And so, and what I mean by that is, if you say no, they're either going to just say, okay, leave you in your job, or your existing location. That's one. Number two, they're going to fire you. Or number three, they're going to impose the change on you anyway and say, if you don't go to the new location, you quit. And then at that point, you can treat it as a constructive dismissal. Okay. Now, you only want to, those last two, you only want to pursue them. So you only want to say no, potentially, if, well, I mean, I don't know about your life circumstances. If you have life circumstances that preclude this, then that's different. But assuming this is just purely a legal and financial analysis, you want to talk to an employment lawyer and find out what your employment contract says and how much severance you're entitled to, how much you have potentially coming to you. If it's 3 weeks, the job may be more important to you. Okay. And then what I would do in that circumstance is actually accept the change, work at the new job while looking for another job where you don't have to commute as far. That's what I would do. And then once you find a new job, just move on. So you treat it as an extended working notice period that you give yourself. But if you have a large amount of severance coming to you, then you may want to just say no and see if they terminate you. That's ideal, or impose it on you, in which case you can claim constructive dismissal. But you shouldn't do any of that without talking to a lawyer. And because they've just asked you to do this, you need to talk to a lawyer right now, today, or maybe not today, but like Monday, Tuesday. So our information's on the screen. Give us a call. Talk to someone right away. I'll say this, with situations like this, what really moves the needle for you is if you have a specific reason why you can't do this. Okay. Now, again, if they're asking you to drive an hour and a half, I think that's just unreasonable, and I think that's a constructive dismissal. They're asking you to drive an hour. Lots of people drive an hour from the suburbs into the city every day. But if you have childcare reasons or elder care reasons why you can't do this, or medical reasons, such as a doctor's note saying you can't spend that much time in a car, for example, then saying no and saying why, like I can't do it and here's why, and here's my medical note, or I have elder care responsibilities, etc. Here's what I have to do. That really backs the employer into a corner, okay? Because if they do it anyway, you've got a great constructive dismissal claim. A lot of times, though, when you provide a reason like that, the employer just backs off and leaves you in your location. Okay, I've seen it many times. So give that information. Be ready with that information for the lawyer that you talk to. But you should talk to a lawyer immediately, because you have to give your answer immediately, and you have to assess financially and legally what's the right option for you. And really talk through the reasons as to why you really don't want to do this. So, okay, we're almost done. We're almost out of time here. What do we got? We got one more question. That's it. Question from David. Company has delayed payroll twice this month, blaming cash flow issues. That's tough. Are there penalties for reporting options under the Employment Standards Act for late wage payments? Well, insofar as if you don't get paid your money, yeah, of course, the Employment Standards Act mechanisms in BC, for example, the Employment Standards branch can make an order that you get paid these wages. But if the company doesn't have any money, it doesn't have any money, right? So it might be like getting blood from a stone, and you really want to wait 12 months for that order so you can get 2 weeks worth of wages or whatever it is. Here are my thoughts on this, okay? Generally speaking, employees will take one payroll error where they're not getting paid because they have their own bills to pay, mortgage, rent, kids, all that stuff. After that, they start to get, a little skittish with how unreliable the employer is. If the employer is not paying you and saying that it has cash flow issues, I think you need to assess whether or not you want to be there, because the core of your work relationship is you give your labor and they give you money, okay? If they can't give you the money part, the whole relationship falls apart. And so if it were me, you've got to do what you want to do here, but if it were me in your situation, right now, I would be looking for a different job. Because, and this may be a great job, but if the business model just isn't working, where it doesn't have the money, and you got, I assume, bills to pay, dependents, maybe who knows, but I'm sure you have your own financial pressures, and this kind of uncertainty is just not something that most people can tolerate. And if it were me, I would not. I would look around right away. And legal remedies, you can have the best legal remedies in the world, and if the employer doesn't have any money, it doesn't matter, okay? Because they don't have any money. So those are my thoughts on that. Those are all the questions we have today. Oh, Shannon came back and said they won't respond with respect to her questions with respect to her medical leave. Oh, no, she's okay. I answered all her questions. Okay, last housekeeping. If you want to get a hold of us, you can do so. employmentlawyer.ca, help@employmentlawyer.ca, 1-855-821-5900. Join us next week where we have, there it is, Chris Justice at Monday, November 24th, 1:30 p.m. Eastern Time, answering all your questions about all things employment law. You don't want to miss that. He's out of Ontario, so he'll give you an Ontario perspective more than I did. I gave you more of a BC perspective. There are, the law is broadly the same, at least in principle. There are subtle differences between the jurisdictions, but he'll give you more of an Ontario focus. So join us for that, particularly if you're in Ontario. Other than that, thanks for all the great questions. I'll be back, I think, in 2 weeks. We're getting into the Christmas break season, so the holiday break season coming up in December. So I don't exactly know what my schedule will be, but I think I'm back in 2 weeks, 10:30 a.m. Pacific time. Look forward to seeing everyone there. Great questions. Have a safe and wonderful weekend, everybody.